Good morning, Ms. Contartese. As you know, you have 10 minutes.
Please the court, Adriana Contartese for the defendant, appellant Graham Chubbuck. The defendant contends that only an exercise of the extraordinary powers of this court can cure the misapplication and misinterpretation of General Laws, Chapter 123, Section 16F, which allows an incompetent defendant who won't be able to have trial for the period that he remains incompetent to have his criminal charges calculated by the Department of Correction. The Department of Correction takes the most serious offense, the longest sentence, divides that in half, and if the defendant remains incompetent at the time that that period of time has expired, he's entitled to have his case dismissed. In the instant case, the Department of Correction combined charges from two separate complaints and put them together. As a result, two counts of indecent assault and battery that have been completely untested remain outstanding on the defendant's record, if you will, until 2015, when the Department of Correction originally calculated that these two charges should have been, the entire complaint should have been dismissed in 2007.
May I ask you this? Before 2015, isn't there a regular process by which his continuing incompetence is tested?
Well, his incompetence is regularly tested. He continues to have evaluations. And the defendant contends that this misapplication of the statute, these two indecent assault and batteries really should have been dismissed at least 2 years ago. They're going to continue to prejudice him in the evaluations. And in fact, this morning was filed a motion to supplement the record with the defendant's most recent evaluation that now seeks to transfer him to Bridgewater State Hospital. And the very first thing on it is the indecent assault and battery charge. So there's no way he's not being prejudiced by this.
But I'm just a little confused. If you just take the second charge, right?
Which one?
The
B&E?
Yeah, I think it's B&E.
The B&E, yes, that's the second complaint. That's the 06 complaint.
And under that, just say that's the only charge. Under that, as an incompetent defendant, when would that charge be dismissed?
2015.
Okay.
2015, and that's the brief refers to that as the 06 complaint. That's on a separate complaint. The assault and the indecent assault and batteries are on another separate complaint, and that's the 05 complaint. And when the DSC originally calculated this dismissal date, they originally calculated.
So if the indecent assault and batteries were dismissed, but he would still be held. I'm a little lost on the prejudice part.
Well, the worst part of this outstanding crime is that it's a sex offense. It looks bad. It sounds worse. The allegations in the police report are terrible. And as difficult as it is, I would almost say futile, as it is to conference a case with an incompetent defendant, to have been able to have gotten a little bit to the bottom of these untested allegations in the police report, I doubt that had this case been able to go forward, that the complainant, who was the defendant's 22-year-old former roommate, the two victims that were the 15-year-old girlfriend and her friend, this case, I'm sure that the court hears this from criminal defenders, but I doubt that the complainants would even have showed up at court.
But here's my question, though. If he is incompetent, and that, let's say it were dismissed as of 2007.
Yes.
As long as he's incompetent and he's, you say, being moved to Bridgewater, all that information, it would have been dismissed because of this, not because there had been a decision by the Commonwealth not to go forward, right?
That's right. It would have been dismissed because of Chapter 123.
Right.
Yes.
So all the information that still remains part of it would have been available to whomever's looking at it at Bridgewater, right?
Well, I think that the fact that it would have been dismissed, it's not live anymore, I think that there's a lot of a lot less prejudice that would accrue, particularly where the Sex Offender Registry Board.
But what's the prejudice? Is there any evidence that that it's preventing him from becoming competent to stand trial, or is there any evidence that he's being treated any differently in Bridgewater?
Well, the prejudice is that I think that I've included in the record appendix the checklist, if you will, that the forensic psychiatrist or the other person, I think in some cases the psychologist, can be appointed to conduct these continuing evaluations. This is a factor. Whether the case is open or not is a factor. Whether it's a sex offense or not is a factor. There's no question that in fact, my brother, an experienced assistant district attorney, has seen fit now to substitute these untested allegations in the police report for a statement of facts in his brief, and more than once. I can't imagine how a layperson, a non-lawyer, forensic psychologist, MD psychiatrist, would not do the same. And I think that it is a lot different to say he has two open sex offenses as opposed to he has two closed sex offenses.
Yeah, but can't the psychiatrist say, well, he's not competent to stand trial on the sex offense, but he is competent to stand trial on the other one?
I don't know how. I don't know the calculations of the incompetency. I don't know how that would come. But that is not the only point of prejudice that the defendant contends is accruing to him.
Ms. Contertis, let me ask you this. What relief is appropriate in not only this case but in all cases?
Well, I think that the original complaint was that the Department of Correction was acting arbitrarily. By
No, I understand. I understand you saying that, but so what's the appropriate release? What should the Department of Corrections be doing?
The original release date that was calculated originally prior to the combination of the two complaints should be reinstated. I can't imagine that.
For the first complaint.
For the first complaint. Well,
For
the
the indecent
complaints.
A and B.
Pardon me?
For the indecent.
For the two indecents, essentially all the defendant is saying is, look, there are two separate criminal complaints. The statute really indicates that these criminal complaints need to be calculated independently. You can't combine them. Like in Foss, you can't combine two consecutive sentences and cut that in half. In this case, you can't pick all the defendant's outstanding criminal complaints, so that if he has some petty offense and then a very serious superior court defense, the petty offense on the separate complaint.
So you wouldn't be making this argument if, in fact, they both arose out of the same set of circumstances?
Well, they did arise out of the same set of circumstances, we think. But nonetheless, the complaints are separate. And I think that the statute requires that they be calculated separately, as the Department of Correction originally did.
Do you know what caused the change in the Department of Corrections calculation?
In the brief and in the record, I don't think I included the affidavit where defense counsel makes this point, but defense counsel contended that the Department of Correction received a phone call from the ADA on the case, who asked that the release date, the dismissal date, be recalculated, attaching that breaking and entering onto, essentially combining the two complaints together. So it was based on a
But to be
DA's
clear,
request.
what we do here will not affect the length of your client's incarceration.
No, it won't. But it will only affect the dismissal of those two indecent assault and batteries. And
Now,
defense counsel.
Pragmatically, does that mean that if there are, say, 12 different counts and he's incompetent, that on 12 different occasions, when half of the maximum is expired, there have to be sequential dismissals for each? So you have to dismiss the A and B first, and then later dismiss the B, later dismiss the indecent assault, and then later dismiss the B and E. Is that what you're asking us to say must be done?
No, it would go by complaint or case. It would go by
It would be that.
Pardon me?
But isn't this, does anything in the record show, let's take it out of the incompetency area, isn't it the department's policy and it has been upheld of if you are charged with more than one offense for parole eligibility, which is what we're talking about here, they combine the sentences. Don't they do exactly what they did here or not? Do you know?
For parole, well, the defendant hasn't been convicted.
No, I understand that,
Yeah.
but the statute language it looks at parole eligibility. So I'm just asking, take this out of incompetency. For purposes isn't it the department's policy when they have more than one charge to combine the sentences and figure the parole eligibility date by some combination of the two?
When I have jail credits cases, I'm just trying to think. I kind of do the work as they come in. Yes. I think that they will combine those. But again, those are cases where the defendant was competent, either attended trial or had a plea.
This is a remedy that the legislature has created, and they never said anything at all about doing them separately.
Well,
They just said, do your usual calculation, essentially.
Well, and the Department of Correction originally did calculate it as a separate
They made a mistake.
complaint. Well, I think that the second calculation was done at the behest of the ADA. I can't imagine that the Department of Correction, unlike with parole eligibility, where these cases are already on a query because the defendant has been convicted, what are they going to do? Call every district court and see if the defendant has an open case that hasn't been tried yet, that's still in the pretrial stage, and collect all these complaints from Berkshire, from Middlesex, from Suffolk
Yeah, but
County.
these cases arose out of the same incident. And so why isn't the Commonwealth entitled to have the calculation based on all of the offenses for which he could be convicted?
The Commonwealth may very well be entitled to do that if they could win a motion to join the offenses into a single complaint. They should have moved for joinder instead of secretly calling the Department of Correction and saying, "Can you do it this way?"
Thank you, Ms. Constantine. Mr. McGuire?
Good morning, Your Honors. May it please the Court. Peter McGuire, Assistant District Attorney for Plymouth County, representing the Commonwealth. Your Honors, the matter is here under a 211-3. I would suggest that as part of determining whether the Court should exercise its general superintendent's powers under 211-3, counsel would have to make a showing or an argument that there's some prejudice to the defendant here.
Do you know what do the defendants do, or what the department does in cases where there are completely unrelated cases? You know, say a case from Hampden County and a case from Suffolk County, and the defendant has been declared incompetent in both proceedings.
Justice Bean, I haven't seen any particular instances where that's happened, and so I don't know particularly what the department does in those circumstances. But I wouldn't make the argument that I think that 17G would start the whole sentence again here. I wouldn't be here making the argument that would be appropriate. The only reason I'm here to say that counsel's motion to dismiss was properly denied was that these are the two cases that arise out of the same circumstances. These are not two separate counties. These are not two separate instances. This is a B&E that resulted in an indecent once the defendant was inside the apartment.
Sure. Mr. McGuire, may I ask you this? On that motion to dismiss, what precisely was the defendant moving to dismiss at that point? This is after the department has recalculated so that the dismissal date is May 2, 2015. Then there's a motion to dismiss, right? What does the motion to dismiss ask for?
Interestingly enough, the original motion to dismiss asked for the court to apply the district court maximum penalty, or a 2.5 in the House of Corrections, and determine that
On the first, on the May 2005 charge.
On both charges, actually. Their argument was that because the Commonwealth had failed to, or had chosen not to, however Your Honor wants to look at it, indict the matter, that it should be considered under district court jurisdiction, and the maximum penalty should be calculated as 2.5 in the House of Corrections.
So at that stage, forgive me for interrupting you, at that stage the defendant was saying, I'm entitled to dismissal of both.
Yes.
Okay. Then,
as the case wound its way, as appellate counsel took over the matter, the issue became narrowed to the issue as to whether specifically the indecent assault and battery charges should be considered as a wholly separate case from the breaking and entering charges. The argument stems from the fact that there are two separate docket numbers. There's an 05 docket number and an 06 docket number. The reasons why there are two separate docket numbers stem back to the sort of procedural, maybe fair to call it a misstep, that the ADA was handling the matter at the time made in the district court. They dismissed the unarmed burglary charge instead of asking the court to perhaps amend it to a breaking and entering charge, or whatever at that point
right,
determined
so they
that
came
was the
back
more
in with
appropriate
the,
charge. Once that error was realized, a new complaint was applied for. It was some number of months later, which is why one's an 05 docket number and one is an 06 docket number.
So just so that I'm absolutely clear, Mr. McGuire, when the district court judge denied the motion to dismiss both cases, that judge was relying on FOSS?
That judge did rely on FOSS, particularly footnote 10 to FOSS, in which Justice Ireland, I believe, wrote that it's not the charging instrument that's really in question here. It's the charges that are in general that the defendant is charged with. And FOSS, that note was particularly speaking as to whether it was an indictment versus a complaint. Though I think that, and I argued that the judge should extend that language from footnote 10 to encompass the idea that two docket numbers arising out of the same series of events or same event itself should be covered by one calculation by the DOC.
I take it from what you've said, and you don't have to commit yourself, that if it were not the same, quote, underlying offense, we might have a different case here?
Oh, I think absolutely, Your Honor. And I'm not suggesting in my argument that all docket numbers that exist against any defendant should be calculated under one maximum or most serious penalty, as in this case the B&E charge.
But at least here, I take it what you're saying is, the defendant has been incompetent for the period of time that a calculation, an independent calculation, if it were the only charge, might entitle him to a motion to dismiss on the indecent assault and batteries. But we have other charges here with a greater period of incarceration, and because it's all part of one transaction, or at least one alleged transaction, the decision as to how to parse this out is better left until such time as he becomes competent to stand trial.
I think the decision as to when to parse this out is best left to the agencies that are sort of closest to the matter. The Department of Corrections was the one that initially made the ruling, and then the very court in which he was charged out have heard actually not one but two motions to dismiss on this matter, if one would consider a motion to reconsider, a second motion to dismiss. And I would suggest, Judge, that the most important factor here is that these do grow out of the one circumstance.
So if there hadn't been a second complaint filed in 2006, he would be, the cases against him would be dismissed?
I agree that the statute, that 123.16f, would require a dismissal on the indecent assault and battery charge if there were no other charges or if that 06 docket number did not exist. I would agree with that.
And let's assume that if the district attorney had in the first case not filed a complaint for unarmed burglary, but for B&E in the nighttime with intent to commit a felony, so that you'd had indecent assault and battery and the nighttime burglary at the same time in 2005, okay?
Yeah, sure.
And am I correct?
My question is, the Department of Corrections would have calculated the time for dismissal as May 2015.
I would hope so, because that's what it seems that 123.16f would require. In the language of the statute, they suggest the most serious crime that the defendant has been charged with should be the crime that's used to make the calculation for multiple offenses on either the same indictment or the same docket number.
Okay.
And am I correct that in theory you could moot this case simply by indicting the burglary charge and then moving to join?
We could, Your Honor. And also a motion to join would probably carry the same weight. I noted at some point in my brief that there is some concern about the motion to join. Counsel raised it in her argument that given that it's such a fact-specific determination as to whether these two are related events, I mean, the Commonwealth's going to suggest he broke in through a sliding glass door and assaulted someone inside, two people inside, that it would be fairly onerous for counsel to make an argument to oppose joinder without the ability of her client to participate in that and give some other factual version of events. And absent his competency, it would be hard to do a motion to joinder, perhaps even unfair to do a motion to joinder. I couldn't find any case law that specifically prohibited that, but out of abundance of caution, I raised the issue.
Well, at least the representation is that they grew out of the same incident.
Oh, absolutely.
And in all likelihood, they would be joined.
I can't foresee
without opposition.
Your Honor, I can't foresee a circumstance that they would be tried separately. This involves a breaking into a door and immediately after assaulting to the two 15-year-old girls that were inside the door.
So with respect to defense counsel's claim that it would be better to have a motion for joinder rather than have an assistant DA calling up the Department of Corrections, and there's some merit to that. We don't want to have executive branches just talking to each other without knowing. Your answer to that is not clear that the defendant would have been able to oppose or agree to a motion for joinder because defendant is incompetent.
And I think that's certainly a concern, Your Honor. I was unable to find any case that specifically answered on that issue, but it certainly seems a concern in this case. It's a very fact-specific determination as to whether the case
Is
should
there
be
some
joined.
reason why your office didn't just file a motion to, I mean, it has to happen sometime, right? You've got to get these two complaints. I mean, either they're both going to be dismissed or this defendant is going to be tried. Is there some reason when you filed the 2006 complaint, you didn't automatically say, join this with that other docket number?
It would have been the best course of action at the time, Your Honor. I don't know if there was a specific reason why it wasn't. I don't think there was. I think it was perhaps a lack of attention to detail at that point in time as opposed to a tactical decision not to join the two dockets.
Thank you, Mr. McGuire.
Thank you, Your Honors.